Good afternoon, everybody. This is Larry Ringer from the Parent Information Center of Delaware. I apologize for the audio problems we had when beginning this call. We will move forward now. As the operator just indicated, this session is being recorded. If anybody's uncomfortable with that, this would be the time to disconnect. However, people will not be we will not hear people's voices. If you have any questions or any comments, please use the chat box in the lower left-hand corner of your screen. This afternoon, we are going to be presenting a webinar regarding the Endrew F decision by the United States Supreme Court. It's a decision which was reached last year in 2017, which has very strong implications for children with disabilities throughout the country and certainly throughout Delaware. A little bit of housekeeping before we go on. As I indicated, your phones are muted. Secondly, we're going to be, at the end of the webinar, there'll be a screen which will appear, which will give you the opportunity to respond to a survey regarding this webinar. Please use that opportunity. It's very important in providing information to us of two kinds. Number one, it'll be an opportunity for you to give us feedback on how effective this session was, what was strong, what was less strong about this, so that we can continue to improve the way in which we provide training to parents and others. Secondly, it will ask you for some demographic information. This information is very critical to us to ensure that we're reaching all populations, number one, and number two, we do need to report these kinds of data to our primary funding source, the United States Department of Education, so please take the time to respond to the survey. A little bit about the Parent Information Center of Delaware. We've been in existence for more than 30 years now. We work with parents of children with disabilities to help support them in the decision-making process for their children with disabilities. We do this in a number of ways. One is, for example, the webinar that we're holding this afternoon. We also do face-to-face training with groups of parents throughout the state. We work one-on-one with individual parents or individual families. We can do this in a variety of ways. Parents call us, parents email us, we can meet directly face-to-face with a parent, and at times we will attend meetings with a family, for example, an IEP meeting. In addition to that, we have a number of online resources which you can access at our website, the Parent Information Center of Delaware.org. And you'll see a number of resources that you can read at your leisure, which will support you again in the process of advocating for your child and being involved in the decision-making process for your child. As part of our website, we have created a toolkit regarding Endrew F. We'll be talking about that in more detail later on in the conversation, which will include the recording of this webinar and a number of other resources, so that beyond just listening to this webinar this afternoon, you have an opportunity to access those resources, to digest them at your leisure, and to use them. So let's talk about what is Endrew F. As I indicated, it's a March 2017 decision by the United States Supreme Court. This decision is really important because it interprets and strengthens the rights of children with disabilities under the federal special education law, what's called the IDEA, or the Individuals with Disabilities Education Act. I just mentioned the IDEA. The IDEA is the federal law that supports the right of children with disabilities to receive special education. Delaware also has Delaware law, which needs to be consistent with the federal law. The IDEA has existed with different names since 1975. It first went into effect in 1977. It's a very important federal law. It really is the foundation for the provision of special education and related services to children with disabilities. A part of the IDEA is the entitlement that every child with a disability has to what's called FAPE, or a free, appropriate public education. FAPE is the program of special education-related services which a school district provides to children with disabilities and their families. By federal law and state law, those services need to be provided at no cost to the parents. And in order to be receiving FAPE, the child has to have what's called an IEP, which is an individualized education program. So what is an IEP? First of all, the IEP is going to be the foundation of the education, special education, and regular education of every child with a disability. It's what I think of as a blueprint or a roadmap to the provision of special education and other services to a child with a disability. It sets out a lot of really important information. First of all, where are we starting with the child? What's their current ability, both academically and in functional areas? What are the goals that we want to approach for the child? So where are we sailing the ship? What's the port we're leading toward? How will we know whether we have or have not been effective in providing services to the child? How we're going to measure that progress. It also will indicate the special education-related services and other services the child will receive, and it will talk about the placement, the setting in which the child will receive their educational services. So let's go back and talk a little bit more about Endrew F now that we have a little bit of foundation. Endrew F really goes to the central issue under the IDEA, which is how do we know whether a child's program really meets the standard for providing FAPE, or free public education, to the child. The Endrew F decision is the most important Supreme Court decision since the Rowley decision, which we'll talk about in a little bit more detail, which was reached in 1982. There have been very, very few cases which have reached the United States Supreme Court which had any bearing on the issue of special education. Cases will begin in either a state court or a federal district court, then need to move to the appellate level, and only in very rare cases will the Supreme Court actually take what's called certiorari. They will accept a case and will decide the case. And because there have been so few decisions by the U.S. Supreme Court, each decision that is reached has really great importance. Next. Let's talk a little bit about the Rowley decision. First of all, that decision was reached in 1982, which was 5 years after the IDEA went into effect, but it took that long before a case actually reached the United States Supreme Court. It's important to understand who Amy Rowley is to understand the significance and the meaning of the Rowley decision. She was a young girl in the state of New York. She had a hearing impairment. She was able to understand about 60% of what was going on in the classroom. So she, through both using residual hearing and hearing aid and through speech reading, she was able to grasp some of what was going on in the classroom, but only about half what was going on. She had no cognitive delay. She was a very bright young lady. And she was able to not only get passing grades, but better than passing grades, and she was moving from grade to grade without a problem. Next. So what did the Supreme Court decide in Rowley? Again, the Supreme Court was looking at the issue of, is what the school district provided to her without providing an interpreter, did that constitute a free, appropriate public education? The court's decision basically said there were two pieces for a court to consider in deciding whether or not a child was receiving FAPE. One was procedural. I talked a moment ago about the IEP. Was the process that the school district used to develop the IEP, was it consistent with the requirements of federal law? Had an evaluation been conducted appropriately? Was the school district actually implementing what was in the IEP? And secondly, the court found that what Amy was receiving was sufficient because she was moving from grade to grade. Let's talk about the impact of the Rowley decision. First of all, it did not discuss what would constitute FAPE for a child different than Amy. Remembering that Amy was a young woman who had no delays cognitively. Her one disability was her hearing impairment. She was actually thriving in her classroom, but she was only hearing part of what was happening in the classroom. The court found that it was good enough. And the court basically used a standard of some benefit. And they were satisfied that Amy was receiving even a little bit of progress. In her case, she was receiving a lot of progress, but the standard articulated by the Supreme Court in the Rowley case was that if the right procedures had been followed and at least some benefit had been reached for the child, that would be sufficient. Let's talk about the impact of the Rowley case. First of all, it was limited to a child like Amy Rowley. So although subsequently courts interpreted that decision in deciding whether other children were receiving FAPE. In the case, the court was actually limiting itself to the facts in the Rowley case. Following the Rowley decision, a number of special education cases reached courts throughout the country. And many courts that were deciding these issues really interpreted the Rowley decision to being that only a very little bit of benefit was necessary for a child with a disability to receive FAPE. And again, the Rowley case had a great impact because we had been waiting at that point for 5 years since the law went into effect before there was actually a U.S. Supreme Court decision. Unlike the Rowley case, the Endrew F decision affects all children with disabilities. While the Rowley case was in many ways, the court was really limiting itself to the specific facts of that case. The way that the decision is articulated in the Endrew F case is much broader. Endrew F was a child who was in 5th grade with autism in Colorado, and the record in the case shows that he was making very limited progress. While he was considered to be in 5th grade, that did not mean that he was making very much progress, and looking from one IEP to the next, looking at one progress report to the next, there was no disagreement about the fact that he was making very little progress. So the Supreme Court decision in the Rowley case applies to all children with disabilities. It's not limited to a child who is in 5th grade like Endrew F. It is not limited to a child like Endrew F who has autism. It is not limited to a child like Endrew F who was making very little progress. And it was not limited to the particular school district, the Douglas School District in the state of Colorado. That's one reason why it's so important, because it really has impact for all children with disabilities. I want to just reiterate a little bit of what we said about FAPE and an IEP before. First of all, FAPE is the program of services, the individualized program of services that a child will receive to address their unique needs. The I in IEP means individualized. It does not mean identical. It is not okay for school districts to have a generic IEP, which they use for all children with autism, for example. Each child's IEP needs to be designed to meet their unique needs. The program of FAPE needs to be designed to meet their unique needs. Let's talk about what the central issues were in the Endrew F case. Number one, the court really emphasized that the school district need to address each child's unique needs, with a real emphasis upon using data to determine what each child's unique needs were. It also emphasized the requirement that each child be involved and progress in the general curriculum. This means all children, not just children who are in general education all day or children with disabilities like Amy Rowley. The law regarding the IEP has threaded throughout it reference to this issue of how a child will be involved and progress in the general curriculum. In determining what the current levels of performance are for a child, part of that needs to address how the disability impacts on the child's ability to be involved and progress in the general curriculum. The goals need to address how the child will be involved and progress in the general curriculum. The services to be provided to the child need to address how services will be provided to enable the child to be involved and progress in the general curriculum. Now, the court understood that we're talking about children's unique needs. The court understood that, for example, not all children with disabilities are going to be able to take a calculus class and progress effectively in the curriculum there, that we need to look at each child's unique needs. The court really, throughout the decision, there was a balancing between, on the one hand, having ambitious goals for all children with disabilities, addressing how all children with disabilities will be involved and progress in the general curriculum, on the one hand, but on the other hand, recognizing each child has unique needs. It is not going to be the same for each child. It's going to look differently for different children, and that individualized decisions need to be made about how to strike that balance. So again, to reiterate, this whole issue of involvement and progress in the general curriculum is a very important part of the Rowley decision. It is a very important part of the IDEA and Delaware state law. So what does the court's decision in the Endrew F case mean? It means that, number one, each child's IEP needs to be designed to meet their specific unique needs. Those decisions need to be made based upon data. And secondly, the court stated that each child's IEP needed to be, quote unquote, reasonably calculated to allow them to make progress appropriate on their unique needs. We'll go into a little more detail about this in a moment, but that whole concept of reasonably calculated really focuses on the fact that the decisions regarding each child's IEP are individualized, that they are data-based, that school personnel and parents bring to the IEP meeting process information regarding specific to this child, regarding how this child is functioning, regarding how they've been progressing, and that school personnel also bring to the process their knowledge about how children with disabilities learn, about effective research-based methods of providing instruction. So to be reasonably calculated, the program and the IEP really need to be well informed, both by data and by research. Next. So as I indicated a moment ago, reasonably calculated really focuses on the process and the information. So in making decisions regarding the child's specific unique needs, the school district needs to take very seriously the parents' input. Also, school personnel bring their knowledge, as I said, both regarding the educational needs of children with disabilities or children with specific kinds of disabilities and the child's unique needs. All those pieces need to be there. Let's talk a little bit more about reasonably calculated. So in looking at how to develop an IEP, which is reasonably calculated to enable the child to make appropriate progress towards ambitious goals, the school district and the other members of the IEP need to pay attention to information regarding how is the child current functioning, what are the strengths and weaknesses of this particular child, what kind of progress has the child made over time, and this needs to be data-based. There needs to be ways of actually looking at where the child started at the beginning of an IEP and the kind of progress they've made over the months following that. Also, the school district and the other members of the IEP meeting team need to consider the child's capacity to make progress. The IEP team must also consider what special ed and related services, supports, instructional strategies this child has received previously. So we're looking at the rate of progress the child has made, and we want to put that next to what kinds of services has the child been receiving, and then that's the way to weigh whether what we've been doing up till now is working and how well it's working. We also need to look at the child's previous rate of progress, with the services that were provided previously, how the child did, what kind of progress they were making. The court really emphasized the fact that these decisions need to be data-based, that to be reasonably calculated, the process needed to be informed by what we know about the child, how the child has been performing. We need to take seriously what the parent's input is, because the parents see the child in settings other than in school. The vast majority of the time the child spends is with their family outside of the school. Parent input is dramatically important in making this decision about what's reasonably calculated. So as part of this reasonably calculated, again, the IEP team needs to consider, is the child on track to make or exceed grade level success? Are there any behaviors that have interfered with the child's progress? This is something that's really important. At times, it may not be, for example, a cognitive delay that is having a particular kind of setting a barrier to the child's making progress, but their behaviors. And it is important not only to acknowledge what those behaviors are and the impact they've had on the child's progress, but then through the IEP to address how are we going to address those behaviors so they are no longer a barrier. And again, the parent's input is critical. So what does the Supreme Court decision in the Endrew F case mean? It means that each child's IEP needs to provide that child with a meaningful opportunity to meet what the court called appropriately ambitious objectives based on the child's unique needs. In the decision, you'll see that at times the court goes between using the term objectives and at times is referring to goals. In all cases, though, it's talking about those kinds of benchmarks we've set which we expect the child to reach if we've provided effective instruction. Now, the court said that generally, for most children with disabilities, if they're advancing from grade to grade, the IEP is appropriately ambitious. Keeping in mind, though, the court was not talking here about social promotion. The court was not talking about a situation where, regardless of what a child learned or did not learn, regardless of the progress they've made, we just keep changing the label on the child's grade from 1 to 2 to 3 to 4 to 5, etc. In the case, the court was talking really about the child actually learning the things which would support the child moving on to the next grade. And the court emphasized that while progressing from grade to grade in a meaningful way would be appropriately ambitious for most children with disabilities, there needed to be consideration of the unique needs of each child with a disability, and there are some children where progressing from grade to grade, we're achieving proficiency, for example, on the assessments that are used to determine the progress all children are making, that may not be an appropriate measure just for this child. This child will not be able to reach those, but we still need to be appropriately ambitious. Continuing with the discussion of appropriately ambitious. The IEP for each child with a disability needs to include objectives or goals that are appropriately challenging and ambitious, and this is important, in light of that child's unique needs. So in determining what the goals are going to be for each child with a disability, it has to be based upon information about that child, about what we know about the child's disability and how it impacts their progress, about what we know about the services that have been provided to the child previously, and how effective those services were in enabling the child to make meaningful progress. And in looking at the information that needs to be considered with appropriately ambitious, we need to be looking at what services the child is entitled to receive that will enable them to address those appropriately ambitious objectives. One thing to remember is there has been a dramatic change in what we know about educating children with disabilities since the Rowley decision in 1982, since the first versions of the IDEA went into effect in 1977. We've learned a whole lot more. We've also learned that children with disabilities can accomplish far more than we had realized when we're providing appropriate research-based instruction. And so it is important in making these decisions about what's appropriately ambitious to not just rely on the way the school district has always served a population of kids, but rather to look at the unique needs of each child and to bring to that discussion knowledge about the kinds of forms of instruction and support that have been successful in enabling children to progress toward appropriately ambitious goals. And it's important also to remember that when we're talking about these concepts of appropriately ambitious and reasonably calculated, it includes all children with disabilities, including children with the most significant disabilities. Now let's talk about what the Endrew F decision means for your child. It means that your child's IEP, through the IEP process, must identify what are appropriately ambitious goals in light of your child's unique needs. As a member of the IEP team, it is important to help make sure that the discussion does not just focus on, for example, in general, what's the curriculum that the school district uses for children with autism? And what are the goals? There may be a bank of goals that the school district uses for children with autism. The decisions need to be made on an individualized basis based on each child's unique needs and determine what are appropriately ambitious goals for your child. Okay, let's continue talking about what the Endrew F decision means. It means that all goals and services in your child must be based on the unique needs. For every child with an IEP, their IEP must include appropriately ambitious goals and services so that your child can achieve those goals, and to the extent that's appropriate for your child, given their unique needs, be involved and progress in the general curriculum. So if your child's IEP goals have stayed the same from first grade to second grade to third grade and you've seen no change, that's a time to really question the members of the IEP team about whether those goals were set appropriately. Number one, are they appropriately ambitious? Were they perhaps overly ambitious? And in deciding that something is overly ambitious, it is not sufficient to simply say, well, the child has not reached those goals, so we were probably being too ambitious. you need to continue to examine whether what your child was receiving, the special ed and related services, the supports they would receive while in a regular education classroom. So it's important to also look at whether the services have been appropriate and sufficient to support the progress toward appropriately ambitious goals and to enable your child to be involved and progress in the general curriculum to the extent appropriate in light of their unique needs. And if your child has made little or no progress, so we talked a moment ago about the goals looking the same from year to year or from progress review to progress review. Again, there may be an issue if there's been very little progress your child has made. The goals may have changed, but your child has made very little progress over time. Rather than just saying, well, the child's incapable of making more progress, there really needs to be a very detailed discussion about looking at the effectiveness of what's been provided, looking at what school personnel and the parents know about the kinds of instructional strategies and curriculum can be most effective with a child with your child's unique needs. All that needs to be brought to bear in looking at, is a lack of progress due to the lack of some piece of your child's education that needs to be in place, something that needs to be changed. We talked earlier about behavior. Could it be that there are behaviors that are interfering with your child's ability to make the progress that we would expect? So just to summarize, what makes the Endrew F decision so important is that it sets a new, clear standard for what constitutes FAPE. That we are talking about appropriately ambitious goals and objectives, that we are talking about the child receiving the services they need so they can make the progress which is appropriately ambitious for your child in light of the unique needs, and that we're providing all the services, that we're really being very data-based and problem-solving about how we approach your child's education. As I indicated at the beginning of the session, we have created a toolkit which is on our website and which will include a number of tools related to Endrew F so that you can use those tools to follow up from this session or to direct other people to. Number one, I admit it is very long and it's in legalese, but for those who want to actually read the court's decision in the Endrew F case, we have provided a link on our website to the court's actual decision. Secondly, the Office of Special Education Programs at the United States Department of Education has issued guidance. They issued this guidance in December of last year. It's a series of questions and answers regarding what the Endrew F case means. It also is somewhat complex, but my experience is if the questions are pretty clear, it is worth taking the time to read those questions and answers. If in reading those you have questions for us, please feel free to contact us. Some additional resources regarding Endrew F. The National Center for Learning Disabilities has an Understood website, and they created two pieces related to Endrew F. One is the Endrew F Advocacy Toolkit, which has what are called talking points to advocate for your child. And the second is a worksheet which follows the same order as the talking points, but actually gives you an opportunity to prepare yourself for an IEP meeting by preparing the questions you're going to want to ask and looking at the information you're going to want to raise. As I indicated, in a moment you'll be getting a slide which will give you a link to the survey. It really is important to us that you take that survey for two reasons. Number one, because it gives you an opportunity to give us evaluation information about what worked well, what didn't work well during the session. Secondly, it is an opportunity for you to provide demographic data, which are very important to us. First of all, we want to make sure that we're reaching a variety of populations, diverse individuals throughout Delaware, number one. And number two, we need that information in order to share with the Office of Special Education Programs, the United States Department of Education, so they can see who we're serving. I want to thank you all for participating today. one person has asked whether the slides will be available to participants. Yes, we will be posting this webinar together with both the audio and with the slides. It'll probably take us a couple days in order to do that, but that will also be part of the toolkit, the Endrew F toolkit, which we have on our website. Our website is PIC of Del, or Parent Information Center of Delaware.org. When you get there, there's a search function. If you just search for Endrew F, it will take you directly to the toolkit and will enable you to access all those resources. I want to thank you all for participating today. I also want to thank you for your patience. I apologize for the audio problems we had at the beginning of the session. Have a good day. Thank you.